Politically Speaking. I'm Elizabeth Bennion, Chancellor's Professor of Political Science and Director of Community Engagement and the American Democracy Project at Indiana University, South Bend. Former President Donald Trump was convicted of 34 counts of falsification of business records in a state court in New York. This makes Donald Trump the first former American president to be convicted of a felony. Sentencing for this case has been set for July 11th. Joining us today to talk about the legal proceedings of this case is Michael Dvorak, former St. Joseph County prosecutor. Thanks so much for being here.
Thank you.
Now, I want to start by just asking you to tell me what exactly was the charge in this case, or were the charges, and what was it that the prosecutor had to prove, and what was their burden of proof in this case?
I'm not intimately familiar with the charges. All I know is there was a 34 count indictment. That means 34 different and separate charges. I did not read the entire indictment, so I can't really comment on that. But I can explain to you the process of an indictment and how it goes forward. In a criminal prosecution under indictment, that means it went through a grand jury. Different states have different reasons for taking cases to grand jury. In some states, a particular charge needs to go through a grand jury. Ohio, I believe, every felony of a certain level has to go through a grand jury. So a grand jury is a group of citizens that are called to serve, and it is a mini trial of sorts. The jurors are there. There's no defense attorney. The prosecutor and the judge are there. They're the officials in the proceeding, and the prosecutor has to show enough evidence that the grand jury will find a true bill on one or whatever number of counts they find, or they don't find an indictment. They don't find a true bill, and they deny it. One might say it's pretty easy to get that kind of an indictment by a grand jury, and frankly, it can be, but it's a filtering system to stop prosecutors from being over-aggressive in filing charges that have no merit, bringing in a petit jury, meaning a regular jury, to hear the case with a defense attorney on the other side, and place that individual defendant in jeopardy when in fact they had no case at all. The fact that a case goes to a grand jury is not something that's usually brought to the attention of the petit jurors. It's not fair or appropriate to tell the petit jurors that another group of citizens saw this and thought that there was enough probable cause to have an indictment issued. So generally the trial jury doesn't know that, nor should they. But at least it's a filtering system before any individual, you or I, are put on trial for a cause by having someone review those facts. And the court determine whether or not this is evidence that they would admit, and anticipating what would be legitimate defenses on the other side. Again, it's not that difficult if the prosecutor is not overreaching, but it does kind of prevent an overreaching prosecutor from going forward.
So once the grand jury decides to indict and we move on to the actual trial that everybody paid attention to with those convictions, then the burden is on the prosecution, correct?
Correct.
That they have to prove all charges beyond a reasonable doubt for the jurors to find on each individual count.
Yes. There's a presentation of evidence. Defense attorney is there to challenge any evidence that's coming in. The defense attorney and the prosecutor generally know what the evidence is going to be from both sides, why they may not be well aware of the details. There's witness lists that are provided to the other side. The defense in most jurisdictions has an opportunity to review all the police reports, all the sworn statements that the prosecution is going to use. All that's made available to the defense in advance of trial. And sometimes when trials are delayed, new evidence is coming in and the prosecutor shares it. The defense attorney said, I need more time. They get more time to do it. And so there's generally not a surprise in terms of the evidence that's heard. There may be decisions that are made even in advance between the prosecutor and the defense attorney with the judge present out of the hearing of the jury, even before trial or in the midst of trial, about whether or not a certain fact can be admitted and presented to the jury. The interesting role that a judge plays in a trial is neither helping the prosecution nor the defense, but what he or she as the judge is doing is looking at, if a jury comes back with a guilty finding, have I let in too much evidence that's going to be overturning that conviction? I don't want that to happen. Or did I not allow enough evidence to give the fairness to the state to be able to prove their cause? And so they're the referee calling the balls and strikes. And the standard they're looking at isn't just their own personal bias, it's their knowledge of the history of this particular issue being argued before in appellate courts in that same jurisdiction.
It seems like that also opens up a lot of challenges to the fairness of the judge, which is something we, of course, see in this case, which is arguing that the judge may have allowed certain evidence in or kept other evidence out that affected the results. And that very well then could be the grounds for the appeal by Trump's legal team. Is that correct?
Sure, that's exactly right. And again, I don't know all the instances and what evidence was presented. I've caught snippets of news about it and was interested in that to find out how the judge ruled on some of those items of evidence. What actually happens, and the way the system's set up, is it's more beneficial to the defense generally than the prosecution. Once again, the court does not want to, most judges do not want to allow in evidence that they know is on that line, that kind of in a baseball game, whether the ball is fair or foul when it goes outside, the judge doesn't get an instant replay or a camera. That judge has to make that decision, but he or she's going to know some evidence law about how similar cases have been ruled upon before. The judge may even tell both sides, before I make this decision, I'll give you, 2 days, a week, or whatever. Generally, it's done ahead of trial. They don't wait that long during a trial. But the judge will ask each side to brief it, meaning, give me some law supporting your position that'd be thrown out, Mr. Defense Attorney. Ms. Prosecutor, you come up with evidence that says, or case law that says that evidence is admissible. And so that's something that when people listen to it who aren't trained in the law, they're going to say, well, I don't understand that. Well, you don't because you're not trained in the law, but all the parties in that courtroom are trained in the law, and the judge's bias ought to be, I don't want to be overturned. I want to do it right so I don't get overturned, whether that's for or against the defense or for or against the prosecution.
How about the public attention on a case like that? Is that also, in your mind, a check on the judge's behavior, wanting to be fair as possible, given all the eyes on a high-profile case like this?
It should be, and I'm not commenting on whether this judge was fair or not. They gave you news clips on it, and I don't know what the rulings were, and I wasn't really deep in the weeds in any of it. But it should make a difference. There's historical situations in the past where some judges have been affected by the attention and made decisions that were overturned one way or the other. And whether that could happen in this case, it's entirely possible. I don't know. I don't know what arguments about. I have not heard any arguments on the news from either the prosecution side or the defense side about particular pieces of evidence that should have been let in or not let in that gave an opportunity for error. I do know there were a couple of parts that I thought concerned me a little bit when they talked about, there were two different women that were involved, and when they talked about the first woman, sometimes you need to bring in certain evidence to meet an element of the crime. And I think that first female that testified about her relationship with the defendant, my first thought was it doesn't pertain to the case of the second female, why they let it in, and the talking heads that were talking about it on the various channels said that testimony was necessary to prove an element to the case, and that allowed them to do it. Generally speaking, if a person's a bank robber and they were arrested for bank robbery before, you can't bring out the fact they did a bank robbery before. And if there's 3 bank robberies that occurred in the same time as this one, and you're proving this bank robbery that happened yesterday, you can't be talking about the 4 bank robberies that happened in our community within the last 2 weeks. As evidence to suggest this guy did, obviously this one, even unless you're charging all those bank robberies together. I don't want to go too far down a rabbit hole, but the trial court judge wants relevance, doesn't want people hearing evidence that makes you suspicious. They want you to hear evidence that, if believed, should make you believe they did or did not do that crime.
Now, as we think about evidence, I want to think about how the type of evidence presented in a case like this case against Donald Trump works, and how important it is weighing it against something like the importance of witness testimony. So in this case, we have, falsified ledger entries, falsified checks, and falsified invoices, each serving as a separate count. Here, falsification of business records to change the results or affect the results to promote one candidate in an election. And so in this case, you have actual documents, but you also have a lot of witnesses testifying. Which is more important, or are they all equally important as you're trying to make your case as a prosecutor? How much are you relying on paper, documents, that kind of evidence versus eyewitness testimony or witness testimony more generally?
There's a lot of questions in your question, but I'll try to answer it. Neither is more important than the other. At the end of the day, the jurors get instructions. And the instructions are quite detailed, and they're based upon previous instructions in similar cases that court has given. The attorneys are offered the opportunity to present instructions from both sides of the case, in a criminal case, the prosecutor and defense attorney, and the judge is going to have their own set of instructions as well. And they literally have a discussion about the instructions, and of course the judge is the arbiter and decides which ones get heard. I've never heard an instruction that says one piece of evidence is more important than another. There's never going to be an instruction that says this person's testimony, live sitting before you, is any more important than another person's testimony from a deposition that was given and they're unavailable because they were killed in a car accident last night, and now they're not told which one is more important. That's up for the jury to decide what they want to believe and what weight they want to give to it. I will say that in having been both a prosecutor and a criminal defense attorney in my career, I wasn't really involved in paper crimes as much. We had people in our office that did some of those. My colleagues that I've worked with, friends of mine who are assistant U.S. attorneys presenting paper documents, have always said that if the case is relied primarily upon paper documents, that they're easier to prove than testimony, because unless there's evidence that counterbalances said that was a forged document, paper pretty much speaks for itself. It's even, in some cases, more persuasive than video evidence, because sometimes people are suspicious of video. But paper crimes, where all you need is paper to prove a crime, are the slam dunks for prosecutors, and very seldom go to trial because defense attorneys know how difficult. In this case, I understand that paper was important as well as testimony, but they're never told one is more important or more valuable to the jury.
Some of these particular checks were signed by Donald Trump himself, but only a small subset. How important would that be in convicting Trump himself over the sort of argument that, well, people were doing this without my knowledge. In cases like that, is it critical to have his signature on some of these documents if that's such an important part of the evidence?
The little bit I understand about this trial was that former President Trump denied knowledge of it. If they have checks that were signed by somebody else, an employee of his or a person in his direction, a person who generally did this, and the state, this is a state brought case, not a federal government case, and the state proved that this was a check, they would then have the burden of proving that he had some knowledge about that check being done. And that could have been done by people testifying that it was typical that he did that. That could be done by somebody saying, I was there when he told somebody to do it. But there has to be some kind of nexus between the check that's not signed by him, which he's attributed to authorizing. The fact that it's not signed by him wouldn't mean that it couldn't have been at his direction. Likewise, if somebody signed a check, and I'm not talking about the Trump case, but any case, there's your signature on a check, and it's there, and you said, yes, that's my signature, and the prosecutor wants to argue, well, then you committed the crime. And you, through your defense attorney or through another witness, said, yeah, but there was somebody standing there holding a gun to her head, and she either signed their name or she got shot. I mean, that's a gross example of duress. But so the fact that it's signed, the person could say, I didn't direct that to be done, or they had witnesses that said, I did not direct that to be done, then that's counterbalanced against witnesses that might have said, yes, they did direct it to be done. So that there probably wouldn't be a whole lot of debate over Mr. Smith signing that check if I directed him to do it, and if that was a crime, nobody's waste time on proving whether or not Mr. Smith did it. Maybe Mr. Smith came in and said I did it, and they asked him if it was directed. Maybe he didn't. I'm running too far down the rabbit hole, but the piece of paper being signed by you as a defendant or not by you has value in that it was signed and it was a check and it went out and the state proves that's a crime. They've got to make a connection to your authorization of that.
Okay. Now, you did mention the fact that sometimes people distrust videos. They might also distrust certain witnesses. In this case, one of the prosecution's witnesses, Michael Cohen, who made the payments, the sort of hush money payments to Stormy Daniels, was somebody who had admitted or pled guilty to lying to both the House and the Senate security councils in the past. And so he was a known perjurer. To what extent does that play into how a jury is instructed to treat that testimony by a judge, and how the prosecution and defense will handle those kinds of witnesses?
That kind of a witness for a prosecutor is always difficult. In most cases, charging criminal intent, the person that is assisting the defendant in doing their crimes is often guilty of crimes themselves. And so a prosecutor knows going into it in the beginning, it's going to be difficult to do that, to prove it because they're there. In terms of how much is that weigh, that person's testimony, talking about Cohen, who was prosecuted essentially for the same act by the federal government previously and imprisoned for it, made lies initially about having done anything wrong, and then at the time that after he was convicted, then admitted he did things. So he comes in to court and he's testifying because he's got a dislike for the former president, and they argue that that's his motivation. That motivation is a decision by the jury to make based upon everything you learn about him, not from what you saw on television or what you read in the newspaper. They're confined to what's going on in that trial. And there are things that I'm sure, with all the reporting that was done on both the people who wanted to see him convicted and the people that didn't, I'm sure there's stuff that they missed. But the people that didn't miss anything were the jurors, the evidence that was provided, the evidence that was included or excluded, and that's how that process works. But again, you keep going to the question of how much evidence, how much value you put on it. The 12 people that make the decision sitting in the jury box are the ones that decide how much they put on it. There's 12 people. You may have put a lot of evidence on the fact that he was convicted and wouldn't support him. I may have, or the other guy may have said, I think that made the case for me. They then have to negotiate what they think is right. What happened, what I read from the verdict after seeing 12 people is that, and the, I don't know how many hours they deliberated, it was over a couple period of days. They pretty unanimously agreed on everything. A lot of times prosecutors put multiple counts in. Sometimes even the way the statute runs, that doesn't mean if each charge has a 2-year sentence, you multiply 34 times 2. Some charges are inherently part of another crime, and when you get convicted of them, there's certain rules that apply as to whether or not those run concurrently, meaning together, or consecutive. So some of those may have been concurrent with each other, so 34 is cut down in half or whatever. Then some may have been of necessity consecutive, so it goes longer. I have not read the statute, so I can't tell you how that works, but that's typically the case. And some of the things that prosecutors are doing in a large case with number of charges is they may think, well, I can maybe get this count, I'd like to get the top count, and maybe they'll come back with the middle one. Because jurors sometimes compromise. They'll compromise the guilt. Somebody will say, well, I believe that defendant's guilty, but I don't want this most serious crime. I'm going to do the least serious or one in the middle. And people might say, well, is that fair? That's our system. They do that. One of the things that I wanted to comment on, not saying anything about the verdict other than the fact that as an individual doing criminal defense and criminal prosecution, I've got a lot of respect for the jury system. Even in cases that I've lost cases as a prosecutor I thought I should have won. I've lost cases as a defense attorney that I thought I should have won. And I've won cases I was surprised I won, and lost cases I was surprised I lost. I mean, everything happens. But at the end of the day, it's a system that you as an individual sitting in that jury box as a citizen, you become more involved in your government than you do even when you vote. And by the way, they used to restrict juries to people who voted. For several years now, I think almost all jurisdictions have gone away from just getting jurors from voting rolls. They take them from other areas. I think Michigan, if you're breathing, you're going to be on a jury unless you're a certain age or have a disability that doesn't allow you to be on it. Most people don't want to be on juries. Most people shy away from that responsibility. If we're talking about a criminal case or a civil case where somebody's asking for damages. Some people are afraid to be on cases that are going to be very gory with some violent crimes. The majority of people that I've talked to, friends, relatives, and even jurors that have approached me after cases that I've been on either side of, a winning side or losing side, prosecution and defense, they have said to me, you know, I really didn't want to serve on jury, but I think that's been an amazing experience. I'm with strangers I never met or knew before, and we all had different walks of life, different economic situations, but we decided what the law was right there. There's a general instruction that comes out that basically says you're to follow the law unless you find some good reason not to. And that's an instruction that a lot of prosecutors don't like. And that means that if you think that after all the evidence you heard, this person may or may not have done this act, but you don't think they should be convicted, then basically you can do that. You can't say that, but you can do that. And you can do that by all coming together and returning a not guilty, or you can say, I'm not going to convict this guy. Why? Because he's too young and he made a mistake and I don't want him to go to prison. Now you never know what the end result's going to be, and it's improper for either side to argue, don't convict my guy because he's going to go to prison. because not all people go to prison convicted of crimes.
So in this case, we did have 12 jurors, all decided guilty on the 34 counts for each of these individual invoices, checks, et cetera, falsifying business records. 30 days, as I understand it, after the sentencing to say that you'll appeal, 6 months to appeal. So this could be years, couldn't it, before it's finally resolved?
It could be. I don't know that years plural, but at least a year or two in most state court cases. I remember one time I did a criminal trial and it was a sentencing, and the judge stacked the sentences, ran them consecutively, one after the other. And I basically argued to the judge that that's not fair because you could have charged him with 20 more of these crimes. And there was evidence there for it, and they charged 4, and it was all in one short period of time, and they should be treated the same.
Which is a good point in this case, because I know some people are saying it could be 136 years with 4 years per count, but the max in New York is 20, anywhere from 0 days to 20 years. That's a lot of discussion for the judge, so I'm sure we'll all be watching as that sentencing hearing takes place.
Yes.
Thank you so much for being here.
Appreciate it.
Unfortunately, that's all the time we have for this week's Politically Speaking, so I want to thank our guest, Michael Dvorak, former St. Joseph County prosecutor. I'm Elizabeth Bennion, reminding you that it takes all of us to make democracy work. We'll see you next time.
This WNIT local production has been made possible in part by viewers like you. Thank you.